A very good evening, everyone. I'm very happy to welcome you all to today's webinar. Thank you each and everyone for taking time out and being here on this knowledge sharing session. Myself, Mohammed Sanofar, and I'm part of Managing Committee at Bureau for the Empowerment of Arbitration and Mediation, a non-profit organization based in Coimbatore, Tamil Nadu. Before beginning, as a host, I would like to give some important points regarding the webinar. So once the event is live, all the participants' audio and the video is muted by default. Please use raise hand options to ask your questions to the speakers, and also participants can pose their questions in questions tab during Q&A session. Please refresh your browser window if you have any audio or video interruptions or any connectivity issues. So in relation to the connectivity issues, please ping me directly. My ID will be always on the stage. Participants who attended the entire session will be awarded with the participant certificates by filling the feedback form. To begin with, I would like to discuss briefly about our organization, BEAM, and its objectives. Bureau for the Empowerment of Arbitration and Mediation. As we are aware, arbitration is emerging as a very reliable and a speedy remedy for the commercial disputes in our country. Recently, Bar Council of India had issued a notification ordering ADR as compulsory subjects in the curriculum for law students. It only vouches the importance of ADR and its emergence as an inevitable remedy in our country. A group of like-minded arbitration professionals and law students motivate to form this unique forum for arbitration and mediation. The main objective of our forum are to create awareness among the general public and to provide legal training to both legal and allied professionals. To emerge as a bridge between the government law college students and other law college students and the arbitration fraternity in imparting the contemporary knowledge to the students. To regularly conduct continuous professional development session for the benefits of students and also to create awareness about alternative dispute resolution, especially arbitration and mediation. BEAM foster institutional arbitration in the Tier 2 cities, and BEAM regularly conduct seminars or webinars for the law students and the industry professionals. To establish an institution, BEAM's main objective to establish an arbitration institution that is accredited by proposed Arbitration Council of India. BEAM empower the budding lawyers into an efficient arbitration professional. Now, without further commotion, we will turn the time over to our moderator, Mr. Karthikeyan, who is a managing committee member at Bureau for the Empowerment of Arbitration and Mediation. Over to you, Mr. Karthik.
Good evening, everyone. It's been 24 years since Arbitration and Conciliation Act was enacted in 1996, and of the late, it has gained sustained momentum, including the mediation process. Our forum, BEAM, has realized that ADR can develop only via awareness creation among the general public. That is the reason we conduct such webinars with objective of public outreach. We also clearly understand that students are the best ambassadors to carry the message to the public about the importance of ADR, which includes mediation. Such awareness creation only can develop ADR in our country, especially in Tier 2 cities. In that aspect, KFCRI, which is the brainchild of Mr. Inba Vijayan, keynote speaker for today, does commendable job in awareness creation by the way of various training and sector-specific webinars. Kudos to them. Our forum's webinars touch upon various allied topics of ADR. At the present moment, mediation gains importance in the wake of Singapore Convention on Mediation, which is a key topic for today's webinar. It will be elucidated in detail in a short while by Mr. Inba Vijayan. Why mediation is gaining momentum? It's because mediation is fair and impartial. Mediation facilitates faster and cost-effective litigation. Mediation allows personalized solutions and many more such benefits, which will be discussed in detail by our panel of speakers. So, promoting mediation is not just in the interest of the parties, but is also the need of the hour. Our Honorable CJI endorses mediation over the other forms of ADR. As the Chancellor of Law University, he paved way for the first ever post-graduation course in mediation at the NLU Mumbai. An Indian Mediation Act, as suggested by the Honorable Supreme Court, is indeed a promising proposal in India. With this prelude, now I invite upon today's keynote speakers, Professor Dr. N. Kayalvili, Principal Government Law College, Viluppuram, Mr. V. Inba Vijayan, International Arbitrator and Managing Partner, Cove Global LLP, Mr. R. Narayanan, Advocate, Coimbatore Mediator at Tamil Nadu Mediation and Conciliation Center, Madras High Court. Our first speaker to light up the evening is Professor Dr. N. Kayalvili, Principal Government Law College, Viluppuram. Our profound thanks, Madam, for obliging our request to preside the webinar. It is indeed an honor to our forum and the associated student fraternity. In spite of your personal difficulties, you are here, which only shows your commitment and interest towards the students' fraternity. Dr. Kayalvili has about 25 years of academic and administrative experience. She is a dynamic educationist, an eminent scholar with path-breaking contribution towards promotion of legal education specific to the domain of international and constitutional law. She has proven ability in inspiring and transforming minds of young students and scholars across the globe, showing them a way of greater transformation in the field of law. Without further delay, let me welcome Professor Dr. N. Kayalvili, ma'am, to inaugurate the webinar. The stage is yours, ma'am.
Yeah. At the outset, I would like to congratulate the Bureau for Empowerment of Arbitration and Mediation, the BEAM, for organizing this webinar on mediation, the remedy personified. I deem it a great pleasure to be amongst the other guests of this webinar, to be amidst Mr. V. Inba Vijayan. If I may recall, our connection is something more than 25 years old in the sense. As we entered the campus as faculties, he was passing out as a law student out of the famous, the then Madras Law College, and I think he has passed out only at Dr. Ambedkar Government Law College. And I also deem it a pleasure to be part of, with another speaker for the day, Mr. R. Narayanan, the Advocate High Court. Before I would like to just straight away go with my PowerPoint presentation. Sanofa, can I?
Yes, ma'am. Yes, ma'am. You can.
Yeah. Our campus at Viluppuram, I've been given a chance for giving inaugural address of this webinar. At the outset, I would like to thank Mr. Rama Subramaniam, the arbitrator, and also my colleague, Ms. Durga Lakshmi, for referring me to Mr. Rama Subramaniam. What is mediation? One of the alternative dispute resolution mechanism. It is a professional mode of settlement, a sophisticated way of settlement between the parties. Litigants have been drawn towards mediation and have begun to realize its immense benefits. Mediation and conciliation has been seen to lead to resolutions without undergoing arduous trials, and moreover, solutions are arrived at a relatively lesser time. Why now? In times of pandemic and COVID-19, when physical hearing in courts are suspended and norms of social distancing are required to be maintained, piling up of cases before the courts of India, mediation as a tool for conflict resolution that has come into force. Litigants have been drawn towards mediation and have begun to realize its immense benefits. Mediation and conciliation has been seen to lead the resolutions without undergoing arduous trials and resolutions, etc. COVID-19 has given us a global crisis, restriction of freedom of movement is there. There is an adverse impact on various sectors, say business, commerce, and with regards to the performance of contractual obligations, with regard to sustainability of global economy, has really created a setback due to the lockdown that we are seeing. Mediation is deep rooted. In the middle of every difficulty lies an opportunity. We should always look out for an amicable settlement. Mediation, the remedy personified. In today's address, I would like to touch these areas, the history of mediation, and I would like to throw some light on some of the prominent cases that has been decided by the Indian courts, the latest regulatory measure taken up by the BCI in the form of a BCI guidelines, what our Tamil Nadu mediation rules 2010 has got to say, how our international rules, WIPO rules guide us on mediation, and the latest Singapore Convention. And I'm sure today our keynote speaker, Mr. Inba Vijayan, would throw more light on Singapore Convention on mediation. History dates back to ancient Greece and Roman civilizations. What are the words of wisdom? Now it's there, embedded in Bible itself. Blessed are the peacemakers, they shall be called as the children of God. Jesus Christ in the Sermon of the Mount says, do not judge. All patients do not need surgery. Judgment of courts are like surgical treatments. Only cases which are not cured, settled by medicines like mediation, alone should go for surgery. It is the words of Honorable Mr. Justice R.V. Ravindran. Tracing back from Mahabharata, recently, the then Honorable Chief Justice Thakur has observed that mediation was also popular in Indian mythology. In between the tussle of Kauravas and Pandavas, Lord Krishna became the mediator. In this, efforts were taken, but though the god himself has failed, though he had played several roles, Mahabharata teaches us that one should strive always to make peace and not to be hard-nosed. Bhagavad Gita, it is a lot of Hindu perspective on dispute resolution. It has layers that has been explained. The layer of internal dispute within each one of us that needs to be resolved. The layer of external disputes between people that needs to be resolved. It is only when the people try to do their best of their ability to resolve both the internal and as well as the external levels of dispute resolution, we would attain inner peace and world peace. We can do the traces from Indus Valley civilization, where the settlement of disputes were done by puga or board of persons. Besides, in the ancient India, panchayat system existed where the system of arbitration was subordinate to the regular courts of law. The decision of a kula or a kin group was a subject of revision by Srini, which in turn could be revised by the puga. Our famous historian, Sir Henry Maine, observes, central governments then refused to entertain any suit at the first instance and were deliberately referring all of them back to the village panchayat. The village panchayat thus reduced the burden of the central government, helped the cause of justice, and encouraged the principle of self-governance. Traces could also be witnessed during the Mauryan dynasty era, where decision was taken by the body of arbitrators with a system of appeal to the king. With the Kushan dynasty, we find that there is some kind of settlements that have been made, though it is not clear and explicit that a proper mediation was carried out. Dispute settlement during Gupta age, we find that there were separate councils who appointed to decide various matters that come before them. If people could not reach any amicable settlement, it was resolved by the councils. The king presided over the highest court of appeal. In discharging his duty, the king was assisted by judges, ministers, and priests. During Mughal era also, it was more systematized, and villagers, however, resolved their cases within the village courts itself and appeal to the caste courts or the panchayats. The arbitration of an impartial umpire, so-called salis, or by resort to the force. Dispute settlement during Maratha rulers. The clan Patel dominated. It was the panchayat to study the case and pass its judgment impartially or without any bias to the party. Patel refused to conduct lighter judgment or appoint a panchayat, or the disputing parties declined adjudication of the dispute in their villages. Well, it was a duty of a so-called mamlatadar to arrange for panchayat. Story of Panch Parameshwar. The concept of justice, the sanctity of seat of justice, they are represented by the panchayat of the village. Let's look into the pre-constitutional era, alternative dispute resolution during the British period. It dates back to 1899, followed by our CPC in 1908 and our first Arbitration Act of 1940, which was enacted repealing the prior Arbitration Act of 1899, wherein Section 89, Clause A to F, and Section 104, Clause 1, and the second schedule discussed about it. We also have Lok Adalats. The Panchayat in the recent past involved lot of caste disputes. We can't forget the 1982 settlement of disputes that were made out of courts, which started primarily through Lok Adalats. To keep pace with globalization, we have updated it into a new Arbitration and Conciliation Act of 1996. So though this many years have passed, now we are making a frog's leap to realize, now do we have to really use these legislations, or when can we go into the older concept of mediation? Settlement of matters concerning the family has been provided under the relevant order of the CPC, and you also have similar provisions in the Family Courts Act of 1984. The first initiative in the post-constitutional development was taken by Honorable Mr. Justice Ahmadi, the Chief Justice of India, who first of all mooted the idea in 1966. He had voluntarily invited a US-based institute, the Institute of Study and Development of Legal Systems, to make a national assessment of the status of India and its backlogging of cases in the civil courts. Besides, we also have the efforts that were taken up by the Law Commission's 129th report, where it was observed that it must be obligatory for the courts to refer dispute to mediation for settlement. Followed by Malimat Committee report in the year 2002, recommended and suggested to make it obligatory for the court to refer the disputes. After the issues were framed for settlement, either by way of arbitration, conciliation, mediation, or judicial settlement through lok adalats. However, much importance is only given to arbitration and judicial settlement through lok adalats. Only if parties fail to resolve the disputes, the case can be resolved through the court or suit to which could proceed further. With effect from 1/7/2002, we have the introduction of Section 89 and Order 10, Rule 1A, B, and C, where 1999 amendment was made, which has made a radical advancement. This an illustration was beautifully narrated by Honorable Chief Justice Thakur, who says that it's quite sad when the family, among the brothers, when they fight, and finally he had succeeded in mediating among the disputes of these brothers. The thumb rule is that whether it may be a sacred moment or a moment of grace in mediation, when parties loosen the tight knot in their perspectives, mediators are privileged to be a catalyst in that shift. Even our Dalai Lama had observed there are many people in the world, but relatively few with whom we can interact, even fewer who cause us problems. So, when you come across such a chance for practicing patience and tolerance, you should treat it with gratitude. Gratitude nowadays, it's rare. Just as having found a treasure in your house, you should be happy and grateful to your enemy for providing you that precious opportunity. Well, what is mediation? A structured interactive process where impartially a third party who could assist in disputing parties in resolving the conflict with the use of a specialized communication or a negotiation techniques. All participants in mediation are encouraged to actively participate in the process. Mediation, in simple words, as per Cambridge Dictionary, it's a process of talking to two separate people or a group involved in a disagreement to try to help them to agree or find a solution between the problems. Similarly, Blackstone Law Dictionary also defines mediation. Now, the stages of mediation. First of all, you need to convene the mediation. There ought to be an opening session. Communication must be made. Negotiation should be used. Ultimately, closure. One of the greatest traits of an individual can have is the ability to convert any situation into a win-win situation. That is what precisely a mediator do, in the words of Stephen Covey. Disputes can be adversarial or non-adversarial. Non-adversarial includes conciliation and mediation. Disputes can also be personal and commercial. The benefits of mediation, when you think, instead of opting for arbitration or other means of alternative dispute resolution, what do we have to choose? Mediation? It saves time. It saves money of the parties. One problem is that it also considerably minimizes the fee or the perk what the advocate can claim while dealing with a case. The advantages of mediation: it's informal, it's people friendly, it's less complicated, allows party to communicate with each other to the crux of the conflict, helps to identify their underlying interests, helps them to focus on finding the solution by themselves. It strengthens and rebuilds the relationship. Whether all matters can be mediated? No, all matters cannot be mediated. Well, our keynote speaker, Mr. Inba Vijayan sir, would throw you more light onto it what are the matters that cannot be mediated. Arbitration and Conciliation Act, it's a statute in pari materia of all the statutes, prior statutes. As I've already mentioned about the section, subsection 1 of section 30 and section 3, the notion of judicial mediation do discusses about it. Skipping to the Tamil Nadu mediation rules of 2010. The definition clauses of the rules explain about the term mediator, and it goes on saying about the appointment, the panel of mediators, what would be the qualification. Section 6 of the rule 6 specifies about disqualification of persons. The persons who could be disqualified: one who is adjudged as insolvent, one to whom against criminal charges is pending, one who is convicted, one against whom the disciplinary proceedings are framed, would be a very good reason for disqualification, or any other category that is specified in future. The rules has around 28 specific points, starting from venue, preference, cancellation of an appointment, role of a mediator, right? Parties who act, you should appreciate the government of Tamil Nadu in taking the initiative of framing these rules in accordance to our international conventions. The defect as such, you see, it's non-binding ADR method. There is no concrete statute as such which addresses. In fact, Mr. Karthikeyan, while introducing, was pointing out about the mediation bill that is pending. It is so far not yet become an act. That's an irony. So long we have not thought about making an act. At least this Singapore Convention should really motivate us in framing a specific legislation. Now that the government is considering making it mandatory as a part of the curricula, we must think about it. Some of the cases that I would like to throw upon is Motiram versus Ashok Kumar, where it was observed that mediation proceedings, they are confidential in nature, and only it can be executed by means of a settlement agreement, or alternatively a statement that a mediation proceedings were successful, it should be provided by the court to a mediator. In the case of Afghans Infra Limited, it was observed that trade, commerce, contracts, consumer disputes, social liability, these are the subject matter in which mediation can be tried upon. In the case of B.S. Krishnamurthy, it was observed that for marriage dispute also mediation can be tried, and also observed for maintenance and child custody also mediation can be tried. In state of Assam as Union of India, it was pointed out that the frontiers of mediation, by referring the disputes between two states for mediation, could be considered. In Salem Advocates Bar Association, Tamil Nadu versus Union of India, 2005 citation, need was urged that ADR must be looked into, where the validity of section of 89 of Civil Procedure Code was upheld. So, in this case, step-by-step grounds for benefits of mediation has been spelled out. In Tirupura Sundari's case, where section 69A was explained of the Tamil Nadu Court Fees Act was explained, and the court ordered full refund of the court fees when the parties preferred for mediation. It's a loss for the court, because loss of court fee. In spite of it, the courts are coming forward in opting for mediation. And we can't forget this famous South African telecom major case, wherein mediation was resorted, where mother, Miss Kokila Ben, was acted as a mediator to settle the tussle between the great Ambani brothers, Mukesh and Anil Dhirubhai Ambani, which led to taking over of the South African telecom major. Yet another major mediation dispute is Ayodhya, the Babri Masjid's case, where the Supreme Court had appointed the mediators, Honorable Mr. Justice Kalifullah, Sriram Panchu, and Pandit Sri Ravi Shankar. But then, clouds of doubt existed over mediation in Ayodhya case. Though we should say that it is a failure, but then efforts were taken. The 5-judge constitutional bench did not leave anything to chance. Next shift, I would like to focus on the WIPO rules, which throws a light for us as to the procedure that ought to be adopted. Parties must submit their disputes to mediation. Potential mediators are required. Specific expertise on the subject is required. Acquaintance with the technology. Parties to choose the mediator. Through meetings, settlement need to be made even with regards to the royalty issue, assuring future agreements, hostile situation between the parties, and giving conclusion, say, while considering the interests between the parties, what could be the profitable technology that could be used in service of the parties. It also discusses about various sectors for mediation, copyright mediation, copyright followed by arbitration, with reference to technology, with reference to telecom, with reference to biotech dispute, information technology, trademark, pharma, patents, automotive sector, telecom, software, technology disputes, whatnot. WIPO mediation is an area which also being used, that is studied for research and development. We should really congratulate our government of Tamil Nadu and our Tamil Nadu State Legal Services Authority for carrying out a yeoman service. It has established 66 centers throughout the state, and it is taking a great task of ensuring that the grievances of the needy are redressed through mediation. Another aspect which I would like to throw is upon the recent guidelines that has been prescribed by the Bar Council of India and its Directorate of Legal Committee. As our moderator Karthikeyan rightly pointed out, why this webinar? This is the reason. The qualification of teachers has also been guideline has been framed by the BCI to teach mediation and conciliation. Teachers ought to be qualified, right? It should also fit into, say, the UGC prescribed norms. Say, lawyers having at least 10 years of experience can be used for mediation. But a person who's teaching a mediator, can he be a full-timer? For a full-timer, he ought to have other qualifications. BCI has also given guidelines to the, as per the Legal Education Committee, our then Honorable Justice had observed, Bob Day had observed that mediation should be made as a compulsory subject. The Bar Council of India, via this notification, has decided that it should be inducted as a compulsory subject to be taught in 2 streams of law courses, the 3-year courses and the 5-year courses. The academic session must begin in the academic year 2020-21, which I'm afraid it is not possible with the COVID-19 issue to straight away implement this. As such, The academic year 2020 commenced way back in July, and the BCI notification comes little later. And in fact, even to conduct classes, some of the prominent colleges have not come forward in conducting online classes. But I am really proud to, and thankful to the Directorate of Legal Studies, where since July 1st, all 14 law colleges of Tamil Nadu, we are having full-fledged online courses going on. Our classes are not being interrupted. I feel sorry for the students who could not participate, but I should admit that around 40 or 50% of attendance we do get in online classes. Blending judicial and non-judicial dispute resolution is also part of it. Law teachers on mediation, where we need to be trained. Irony. Now, okay, they can be diploma holders. That's what the guideline says. Now, in the Tamil Nadu legal education, we don't permit a diploma holder to handle law classes. In that juncture, to how far Bar Council's statement of opting for diploma holders as teachers in mediation, it's $1 million question. Syllabus I would like to throw upon, where this is a syllabus that has been prescribed if implemented, 45-hour mediation, right, with one semester, 9 to 14 weeks. These are the aspects that has been covered: understanding conflict and disputes, mediation and restorative justice, mediation laws in India, key concepts in mediation, importance of communication, conducting effective mediation, qualities and skills of mediators, status of mediated agreements, important developments in mediation. I would also request Mr. Inba Vijayan to once again look into it and give a critique of whether this course is sufficient or does it require any amendment. If so, we can always suggest. There's a syllabus on mediation.
Excuse me, ma'am.
Yeah, I'm going back.
Yeah,
this is a week. I'm completing.
Sure, ma'am.
So these are the weeks that has been prescribed. So LLM courses is being suggested, wherein we find that not so far we have any LLM course on mediation. And henceforth, now the Tamil Nadu government had considered introducing new six LLM courses throughout government law colleges. This mediation should also be considered. So the guidelines for internship has also been prescribed. So there is a proportion of theory versus practical content which need to be analyzed in depth in considering this syllabi. So it also discusses about recommended reading. Singapore Convention, our Inba Vijayan sir would throw more light onto it. The way forward, I would like to take a minute in concluding my inaugural address by saying that the role of the courts or arbitrators is adjudicator, and it is more formal in nature. In contrast, the nature of mediators, the process of mediation is very practical and flexible. It is a speedier, effective, economical, adjudicative process. It's a usable tool. It fosters peaceful and healthier interpersonal interactions. Mediation needs to be promoted. Building awareness regarding mediation and invoking mediation as an alternative dispute resolution process will supplement the functioning of the courts and make access to justice a more efficient and effective way of settlement. I take this opportunity to thank once again the organizers, the BEAM, for giving me an opportunity to make this inaugural note. Thank you.
That was an inspiring and resourceful speech from Professor Dr. N. Kayalvili.
Yeah.
And we expect it to transform the young minds here. Thank you so much, ma'am, for your wondrous presentation.
Thank you.
Now, without further delay, let's welcome our next keynote speaker, Mr. V. Inbavijayan, renowned international arbitrator and managing partner, Global LLP. Mr. Inbavijayan requires not much of introduction. He is already a popular name in the ADR arena, not only in India, but overseas. Mr. Inbavijayan is an alumnus of prestigious Dr. Ambedkar Government Law College, University of Madras. His enthusiasm towards ADR made him to pursue whole-time arbitration practice since 2001. He is currently the managing partner at Coke Global. Another notable feat is the establishment of KFCRI, which has created tremendous awareness about the various domains of arbitration. KFCRI is already an icon in the ADR arena, and they inspire young organizations such as BEAM. He has presided as sole arbitrator and represented a council in over 300 domestic cases, several small claims, commercial arbitrations, and 14 international arbitrations. His areas of practice includes international commercial arbitration, maritime arbitration, and then construction disputes, finance and banking disputes, etc. He has been accredited as an arbitrator in HKIAC, CITAC, RCAKL, ICA, CIDRA, and various other regional and national arbitration institutions. To add up, he is a co-founder and former secretary of an arbitration institution, CNICA, and inducted as a member of ICCA. He is an approved tutor for all courses or modules of Chartered Institute of Arbitrators, UK, and had been listed in the 2008 edition of International Who's Who of Commercial Arbitrators. Chambers Asia Director has continuously listed Mr. Inbavijayan for 5 consecutive years since 2009 in dispute resolution and arbitration, and was recently listed in Indian Lawyer 45 under 45. We take pride in hosting you, sir, in this webinar. The student community and the professional fraternity is eagerly waiting to hear from you on the very current topic, which is Singapore Convention on the Mediation. Welcome to the stage, sir.
Thank you. Thank you, Mr. Karthikeyan. Good evening to one and all. It is always a great opportunity for me to advocate the concept of ADR. And today, BEAM has given me this opportunity, along with my esteemed lecturer, I think 25 years back when Professor Dr. Kailvili ma'am was a teacher there. I graduated and had an opportunity to get to know about environmental law in a particular program where Professor Dr. Kailvili ma'am organized, and it was an interesting platform. And that was my first platform to come among a few individuals to successfully talk about the effect of mediation, and particularly mediation in environmental disputes. That's how I had an initial intro about this mediation and the other ADR mechanisms. I'm also thankful to have a colleague, Mr. R. Narayan, who is attached to the Tamil Nadu Mediation Conciliation Center, which is far more developed when it comes to court-annexed mediation in our country. Having a brief introduction about the speakers and co-speakers and my start with mediation, I'm really happy that the major portion has been covered by Professor Dr. Kailvili ma'am. It is interesting that from an academician's presentation, particularly an inaugural address, wherein she has in detail covered about this history, about mediation, the evolution of the laws in our country regarding mediation, the present case laws which has dealt with mediation, and most interestingly, the aspect about the court-annexed mediation, and finally the recent notification of the Bar Council of India regarding mediation to be a mandatory subject, which is going to be really a great boom or a career boom for young lawyers and law students or aspirant law students who are quite interested to get into the law, and more particularly the alternative dispute resolution. The topic wherein I have to just deliver the keynote address is on Singapore Convention on Mediation. everyone would be happy to hear the name Singapore. I think specifically some of the committee members of BEAM who had an opportunity to live in Singapore. It is always considered to be a premier nation. Even though it's a small city-state, it has a quality of a premier country as a whole. This particular concept of mediation, not only mediation, Singapore is the best place in Asia or in the Far East to deal with alternate dispute resolution. Why? What is the reason behind it? A simple understanding is that the perspective of the government, the perspective of the judiciary, and the perspective of the beneficiary, all the stakeholders, the government, the judiciary, as well as the stakeholders, all have the same perspective of promoting the nation as a model nation. And one such effort is to bring that country itself as a best destination for alternative dispute resolution. That is the very purpose of taking Singapore as a role model for any jurisdiction, whether the oldest jurisdiction like the London, the Paris, the Stockholm, the New York, all these premier destinations for alternate dispute resolution is now being challenged by Singapore. And Singapore, with this perspective or approach on the promoting the ADR concept, initially gave this opportunity for arbitration. If you look on the Singapore model of arbitration, they have a very peculiar system of having two arbitration legislation, one dealing with domestic and another with international. The core mediation can be understood when having a comparison of this arbitration. They have two different legislation, and when a foreign party who wants to have an international arbitration in Singapore, eventually they will be given option to opt for the international arbitration law of that country. And interestingly, that particular law gives an option for the parties to take a leverage, wherein that leverage would make the minimal role of courts. The court's intervention would be minimal. If the judiciary is having a minimal role in an arbitration, then that destiny would be really a hub for international arbitration. That's how they initially started with the Singapore International Arbitration Center, which is now considered to be one of the premier arbitration institutions, not only in Asia and the total globe. It is considered to be the best destination with a reasonable cost and having the best expert. This is how they had their hierarchy of development in ADR. And this development was even mooted with the bringing in of the mediation. The mediation convention, which is which has to be addressed as the United Nations Convention for International Settlement Agreement, had its shape in the year 2018. I think it's the 73rd session of the General Assembly of UN, which literally had a working group on conciliation and mediation. And this particular mediation, UNISA, got its initial shape. And that shape came into reality on 7th August 2019, when 46 countries, it's the first time in the history of any convention to be signed on the day one of that convention. 46 countries, including India, signed this convention. And interestingly, India, US, China, obviously Singapore, and many interesting nations have signed this particular convention. This convention, and more particularly, what is going to be facilitated by signing or ratifying this convention? The straight answer is that this convention is going to facilitate the mediation, which is considered to be alternative dispute resolution, is now going to be an appropriate dispute resolution. That is the very objective of this convention, wherein all the international mediated settlement agreement are going to be enforced. Enforcement with the ratifications of this convention would eventually bring out mediation legislation in most of the developed jurisdiction. As rightly Professor Kalvili ma'am was highlighting about what happened to the Indian mediation bill, it is on the pipeline, and because of this signature, what has been placed by the government of India on 7th August 2019, we are going to have a mediation law. But only thing we have to wait and see to what extent, whether it is going to penetrate inside the Arbitration Conciliation Act or as a separate legislation. There is a discussion going on to consider replacing the term conciliation in the Arbitration Conciliation Act and place it as mediation. It can also be the future that it will be Arbitration and Mediation Act with the amendments inclusion of mediation alternative to conciliation. This is the major objective of this Singapore Convention. But here, I want to just get back to the earlier situation of ADR, particularly in India. When you look on the history of ADR, and most particularly when it was highlighted about the section 89 of the Civil Procedure Code, which happens to be the first development of the term mediation in our country, which brought in and which also being facilitated by the AFCON's judgment, literally gave an opportunity for the Apex Court in India in 2019. Two interesting cases wherein the judiciary was in favor to bring a mediation legislation. The actual concept of Indian Mediation Act, or a promotion to bring an Indian Mediation Act, started by the very observation in a very interesting case wherein the former judge of Supreme Court, Justice A.K. Shikri, asked the government to have a feasibility, a study on to have a authority called MAMA. It is Motor Accident Mediation Authority. This was the first time the Apex Court gave an observation asking the government to look into establishing an authority, which authority is going to deal with the dispute solely with mediation. Very interesting development. And that development led to the very historic dispute resolution with the Babri Masjid case, wherein three Tamil-speaking, very interestingly, all the three Tamil-speaking mediators were appointed, and those recommendations given by the mediating committee ultimately solved the historical dispute of the Babri Masjid or the Ayodhya dispute. This 2019 year was really a very fruitful year for India with these two Apex Court judgments. And before and after this particular development, we had 3 C's. Interestingly, when we see about C's, it gives a different notion of CVC, CBI, and other component. That's a CAG. But now, when it comes to mediation, the 3 C's has given a perfect beginning for mediation. And those 3 C's are: 1, the Companies Act 2013, then the Commercial Court Act 2015, and then the Consumer Protection Act, the Amended Act 2019. These 3 C's, the legislation, were interestingly promoting mediation as a pre-mandated mediation in all the litigations, whether it is going to the National Company Law Tribunal, whether it is going to the commercial courts, or whether it is going to be the Consumer Protection Forum. First, try with mediation. This is a great development, and this development also is a replica or a model which has been adopted from Singapore. In Singapore, there is a process wherein every small and less complex dispute which is being filed in the courts, the Singapore national courts, those matters have to be referred to mediation as a mandatory condition. The registry of the Singapore courts have to refer the matter to mediation, and the mediation process, if it is successful, the matter ends there. If it is unsuccessful, then the matter can be effectively dealt as a civil suit. This great development in Singapore also was adopted as a pre-litigation mediation process in all the 3 C's. These 3 C's is really a boost for mediation in our country. And along with this, the court annexed mediation. This is another C. The court annexed mediation, which I think started actually in 2004-05 after the famous Salem Bar Advocates Bar Association case. The state of Tamil Nadu was the first pioneer state, along with some development in Ahmedabad as well as in Bombay, which brought in the concept of court annexed mediation. And this court annexed mediation created this Tamil Nadu Mediation Conciliation Center, which is doing an excellent platform, and it is working really well to resolve all the disputes, whether it is going to be a commercial dispute, or whether it is going to be a community dispute, or whether it is going to be a family dispute, or whether it is going to be very basic disputes pertaining to insurance, telecommunications, intellectual property rights. All type of disputes are literally being managed in a very modern, sophisticated and a standard way of resolving in the court annexed mediation process. And not only that, in all the 66 centers attached to the courts or the judiciary, Tamil Nadu judiciary, it's all very successful, and this model is also being replicated in New Delhi, in Chandigarh, and all the jurisdiction in our country. And this model is another C which all facilitated the success in mediation as of now. Having said these, whether it is going to be the community dispute or commercial dispute, there is still some restriction of taking certain disputes to mediation. It is not that we can take all the disputes to mediation. Certain disputes, it is restricted to be taken to mediation. And for this, very interestingly, the Singapore model, the Convention on Mediation, gave some reservations. And one reservation, very interesting reservation, is if you have a chance to read into particularly the Article 8 of that convention, it speaks about exemptions. And one country, that is the Republic of Belarus, I think now it is very hot dealing with the country of Belarus, wherein Lukashenko is claiming that he has won that election, and there is a huge cry, and every day there is protest in this country. But that country also was initial 6 countries which has signed and ratified this particular convention, where they have quoted Article 8. I'll just try to read it. In accordance with Article 8 of the Convention of the Republic of Belarus, shall not apply this convention to settlement agreement to which it is a party, or to which any governmental agency or any person acting on behalf of government agency is a party. And not only Belarus, it is the Islamic Republic of Iran, as well as the Kingdom of Saudi Arabia. All these, many more countries have this reservation. All these countries have taken an important reservation, wherein the sovereign state or any state agencies would not come under the purview of this particular convention. That means, if there is going to be a legislation in those jurisdiction, those legislation can't deal with dispute dealing with government agency as well as a sovereign state. It is a beginning. Anyway, whatever convention comes, there will be some reservation. That reservation is considered to be an impediment for all disputes to be taken to ADR mechanism. But it is a good start. This start is going to give a great opportunity. It's not a simple opportunity. It is a great opportunity to resolve the disputes at a reasonable cost, a reasonable time, And not only that, this is going to facilitate that effective administration of justice in any jurisdiction. It is not only in India where we have a problem of docket explosion. Every developing countries have this issue. At least in India, we can see the final outcome, the final judgments of any dispute, unless it is complex, within a reasonable period. Major developed countries, it is a decade, minimum of a decade, for any civil suit to be disposed of. And if you could see, when there was the condolence message given for the former the judge of Supreme Court of US, they were very happy to say that that particular judge, in the span of, I think, 27 years, in 1993, she was elevated to the judiciary. 27 years, she could effectively complete 480 cases. But it is not the record. What actually happening in India? We are really more effective to deal with civil cases in the courts. But still, considering the population and considering the volume of cases filed here, we have to find the best alternatives. The best alternatives like Lok Adalat for small claims, arbitration for wider range of disputes, now mediation for all the possible disputes which can be resolved with a reasonable expertise. That's also very important. Expertise is not required in a mediation. It is not that only the lawyers and the persons with legal knowledge can advocate this mediation. This mediation can be advocated by any professional or any person in this country. And this is going to be a great platform, particularly after the, particularly India is going to ratify, when they're going to ratify and bring the Indian Mediation Act, then it is going to be the reality that anyone can mediate. And if anyone can mediate, like the mediation what Ambani's mother, as well as Lodha, earlier Lodha, RS Lodha mediation, and many big family mediations, all those mediations can be effectively dealt under a law, and we will have the only element which is going to be the success of that mediation, that is enforcement. Right now, we bring this mediation, which is also the alternate dispute resolution, which doesn't has a binding nature. It is a non-binding process wherein the outcome can be only the binding agreement, not a binding decision. This is going to change when we are going to have the ratification of that particular convention. And once the ratification is there, we are going to see enforcement of the settlement, the mediated settlement agreement. Right now, we have this conciliation, the conciliated mediated settlement, which gives enforcement. It is also treated like an award, like a consent award, but still a mediation, if you are doing a process mediation, then that outcome has to wait for this convention to be ratified to have the enforcement. If we have that enforcement, the option for parties choosing mediation would be abundant. That is the message what I wanted to say as an introduction. Now, I will take another 5 to 10 minutes to share what I wanted to say about this convention and the content of this convention. As I just mentioned, 46 countries signed it, but on 12th September 2020, hardly 2 weeks back, this particular convention came into force. And at that point of time, 6 countries have ratified. And interestingly, the ratifying nations happened to be Singapore on 25th February, along with Singapore, Fiji, a country adjacent to the Australian continent, they signed. And then we have countries like Ecuador, Belarus, then we had country like Qatar and Saudi Arabia. Singapore, Fiji, Qatar, Saudi Arabia, Ecuador, and Belarus. All these 6 countries as of now have ratified. That means these countries have started working on to bring a mediation legislation in their jurisdiction. That is also going to happen in India. This particular development, what is happening in other countries, is also going to be evident in China. It is going to be evident in US. It is going to be evident in UK, as well as many European nations. And when you see some conflicts, I just wanted to highlight before sharing this presentation. There is some conflict which is very recently come across, East Mediterranean conflict between Turkey and Greece. There was a tussle dealing with some oil exploration in the Eastern Mediterranean region. And now Turkey is trying to take it to mediation. And literally, if you see that mediation, Turkey wants to bring a particular disputed region called Turkish Cypriot. That is in a part of Cyprus was already invaded by Turkey quite a long period back. And that region they wanted to bring as a party. Why? Because that region is a region which is geographically near to that oil exploration. This is one example. Likewise, we have South China Sea conflict. We had the earlier ethnic conflict in Sri Lanka. Now, we also have this blockade of Qatar by various emirate nations along with Saudi Arabia. All these conflicts, it is all public conflicts. All these conflicts also can be mediated. There is no restriction. Only restriction given to mediation is regarding a reservation by countries as well as criminal issues. A criminal offense cannot be mediated. That too, in some countries, small petty criminal offenses are taken to mediation. Okay, now I like to share this presentation, which is I prepared for this keynote address on the Singapore Convention. This is a very beautiful picture of Singapore, and we can see this country has facilitated this particular convention. Okay, now it is simply called as a Singapore Convention on Mediation. Convenience is better than considering UNISA. UNISA is quite a technical term. We can always go with the Singapore Convention. But initial signatories, the good thing is that the major players, US, China, India, and South Korea, have signed on August 7th. That is a good sign that has to be appreciated. The Indian government also, within a week's time, they decided and they signed it. And what is the aim of this convention? This convention aims to resolve issues with cross-border enforcement by making mediated settlement agreements directly enforceable by courts of all the state parties, that is the signatories to the convention, and to promote the use of mediation to resolve cross-border commercial dispute by enhancing the enforceability of international mediated settlement agreement. Since this convention is for international, it is all given in an international perspective. We have to wait and see how it is going to be adopted in the municipal laws, the municipal mediation laws. This is just like how arbitration we are going to understand. The Arbitration Conciliation Act also has the backbone of the unsettled model law for international arbitration. The same way we have to look into this convention. And further, as an aim of this convention allows parties to the settlement agreement to invoke those agreements before the courts of that particular state parties to establish that matter has already been resolved via mediation. If the matter is resolved via mediation, that can be effectively enforced by the national courts. And most interestingly, once the court and the state party is presented with a request, it must act expeditiously to enforce. Very important. The mediation has to be effectively, not only effectively, expeditiously enforced. This is very important. Enforcement should not take its own time. It has to be within a reasonable time. Okay, now, what are the things the settlement agreements cover? There are some 4. One resulted from mediation. Another is related to commercial dispute, and it is in writing, obviously it has a international character. International. What is international? At least two parties to the settlement agreement must have their place of business in a different country, or the state party with which the settlement agreement is most closely connected, or in which it must be performed, must be different from the party's place of business. It's very simple. When you're dealing with a party in having a different jurisdiction, obviously, or doing the place of business happens to be in different jurisdiction, it is considered to be international. It's similar to a normal other convention. And interestingly, the convention does not apply to certain aspect. That is, the convention is not applicable if the settlement agreement has been concluded or approved in the course of a court proceeding and is enforceable only as a judgment or it is an award. Please understand, we have to distinguish between arbitral award and civil court judgment. Whether it's a civil court judgment or an arbitral award, it is not considered to be a settlement agreement as per this convention. The courts or the award can be out of settlement, but still it is not confined as a settlement agreement. Some other restrictions, what I just highlighted, that is the Article 8 of the convention, that is what I have just given as a first point. A state party may exclude application to settlement agreement to which the state party or its governmental agencies are party. This is a suggestion given in the convention itself, and rightly the Republic of Belarus, the Islamic Republic of Iran, as well as the Kingdom of Saudi Arabia has taken this reservation as a restriction for when it comes to enforcement of settlement agreement. There can't be any settlement agreement dealing with the sovereign state or the government agencies. This we have to wait and see. This is a major difference between the Singapore Convention and the New York Convention pertaining to arbitration. In New York Convention, we don't have so much of reservations, but when it comes to Singapore Convention, we have this reservation, at least to begin with. We have to wait and see whether there is going to be any relook on this particular reservation or restrictions. Okay, now when it is going to be non-enforceable, yes, there are some 10 points which speaks about non-enforceability. The first one, if a party was under some incapacity, a settlement agreement is, even though it has been derived, wherein one party happens to be a party who doesn't possess the capacity to even contract or even enter into an agreement, that settlement agreement cannot be enforced. Then the agreement itself is null and void, inoperative, or incapable of being performed under the law. Then that settlement agreement also cannot be enforced. Third, the agreement is not binding or is not final, like an interim agreement between the parties, then that agreement also cannot be considered for enforcement. Fourth, the agreement has been subsequently modified. If the agreement has a modification, then that also cannot be enforced. Then the obligation under the agreement have been performed or not clear or comprehensible. If it has already been performed, then also we have to consider or bring it in the category non-enforceability. Too much of restrictions. 6. Granting relief would be contrary to the terms of the settlement agreement. Something different is expected as a relief that also cannot be enforced. There was a serious breach by the mediator of standards applicable to the mediator or mediation, without which the party resisting enforcement would not have entered. Serious breach by the mediator of standards applicable. Where comes the standard? For mediation, we have a forum which is called the International Mediation Institute, which brings down certain standards. Those standards, if the mediator breaches, there are very, very prominent standards and very hard standards to be followed. If there is a breach, then that mediated settlement agreement also cannot be enforced. 8. The mediator failed to disclose to the parties circumstances that rise to justifiable doubts regarding his impartiality or independence. 9. The granting relief, it is contrary to the public policy of the state. We can't just enter into a settlement agreement and expect it to be enforced, wherein that settlement agreement is contrary to the public policy of the country where we are going to enforce. And finally, the subject matter of the dispute is not capable of settlement by mediation under the law of that particular state. All these are considered to be non-enforceable. It's a big list. 10 is a big list, and wherein we have to wait and see how this convention is going to be relooked once it's going to be adopted or ratified by various countries. And finally, in this PowerPoint presentation, I wanted to just say what would be the implication when it comes to cross-border dispute resolution. The mediation is generally faster and less expensive than other forms, no doubt on it. It also tends to preserve commercial relationship to a greater degree than any other form of dispute resolution where there are clear winners and losers. That means the outcome of a mediation, whether it is going to deal a normal dispute, a personal dispute, a commercial dispute, or it's a cross-border disputes, the outcome would be a win-win situation. A win-win situation is the mantra and thumb rule of any mediation process, and this convention also is expecting to be implied for cross-border, that is international disputes also. And the proponent of the Singapore Convention of the Mediation is expecting to give a boost for the enforcement of mediated settlement agreement, and it will be a good complement and an alternative to the New York Convention, which normally gives to the arbitration. Yes. Friends, what I had just mentioned earlier about the situation before the Singapore Convention or during the time of the Singapore Convention, or looking into the convention itself, to what extent it has certain reservations or restrictions. Anyway, it is a good start. This start is going to facilitate mediation in our country in all type of disputes with some restrictions. But this is going to make mediation not an alternative dispute resolution. It is going to make it as an accepted dispute resolution, an authenticated dispute resolution, and an appropriate dispute resolution. And to just add on what expected from the inaugural address made by Professor Dr. Kailvili ma'am, is that how it is going to be imparted. The education of mediation, how it's going to be imparted to law students. We have to wait and see. Whatever the notification has mentioned about who has to teach, I think their expectation is that a practically exposed person in mediation, particularly the mediators who have been working in the court annex mediation to begin with, would be the best person to advocate and teach this particular subject with a 45 hours course which has been recommended, or the subject curriculum has been recommended. We have to wait and see, and this itself is a good take, wherein the law students who are going to lead this, who are going to facilitate this particular ADR mechanisms to the entire society, as our father of nation so often quoted in any of the presentation by any mediation practitioners or lawyers, that any person, if even he is going to lose some portion of his revenue, he is not going to lose his soul. The satisfaction, what is going to be the ultimatum of any person, particularly the lawyer. The law profession is a noble profession wherein we are there to save the society. We are there for a harmonious society. We are there to have a developed society with a proper civilization. We are also going to facilitate this particular mediation with the theoretical knowledge, which is also required. Certain processes has to be taken in a theoretical, in an academic way, so that we can have a real standard. The real standard, what is expected for a mediator or the mediating parties, that has to be educated in a proper manner. To begin with, we have to depend on the practicing mediators, and in future there will be academicians, full-time academicians with reasonable knowledge on the practicality of the mediation process, wherein these curriculum would bring productive lawyers, young lawyers who are going to advocate this mediation mechanism, wherein the society is going to thrive, evolve, develop, and ultimately be an effective platform for a certain living without any disturbances. All these are very much required. A peaceful country, a peaceful society, a harmonious society, it is a must of the hour, and for that, mediation is going to make it realistic, that too through the Singapore Convention on Mediation. Thank you.
Great to have Mr. Indra Vijayan with us, and it was enlightening speech about mediation. Thank you so much, sir. And let me welcome our next keynote speaker, Mr. R. Narayanan, advocate, Coimbatore mediator at Tamil Nadu Mediation and Conciliation Center, Madras High Court. He is having 30 years of law practice in civil side and 15 years of experience in mediation. He is a panel advocate for SBI, LIC, and etc. Besides, he is an accredited mediator at the Madras High Court Mediation Center. Trained as a mediator under Srimati Geeta Kulkarni and received the distinction of accredited mediator. And he was planning for some live demo sessions today, and due to some technical issues, we were not able to conduct that session. Instead, we will have more interesting and interactive session, and for that, we welcome you to the stage, sir.
So,
we can hear you,
good
sir.
evening, all the persons who are attending this. At the outset, I thank very much for the team of Beam who have given me an opportunity to address you all. I equally thank Dr. N. Kayalvizhi, Mr. V. Indra Vijayan, the keynote speakers of this gathering. The problem of mediation is not something new to India. If we see the pages of Ithihasas and Puranas, you can see a wonderful story of Krishna in Mahabharata. Krishna will be speaking at a particular time. Both Arjuna and Duryodhana will come for getting his help for the Kurukshetra war. Krishna first will see Arjuna, who will be in the leg portion of Krishna. He will promise him that whatever you want in the war, I will come and help. And immediately he will see the other side, Duryodhana will also be there. So it becomes a catch-22 situation for Krishna to satisfy both. So Krishna, first time he applies the art of this mediation win-win situation, where he says, I will come and attend the war, but I will not take any arms. The other alternative is, I will give the entire Narayani force consisting of various Akshakonis, and they can take it. Either of the two, both of them I am giving, you can take the options. Arjuna will choose the option of, Krishna, it is enough if you are there with me. I don't mind you not taking any arms. But Duryodhana will think, if the entire Narayani force comes, I can easily win the war. That is the mistake that Duryodhana did. Here, Krishna diplomatically solved the issue. It is a win-win situation for both, and this concept of mediation is not something new to India. It is already prevalent in our books. Earlier, the panchayat system was there, and it is also more or less like this. But the only thing is, nobody here, the compulsion will be there. In panchayat system, if you are not attending the panchayat system, sanctions will follow. But that is not there in the new developed mediation. Let us see what the mediation is and how it came to India. I am really proud to say that it is our High Court, the Madras High Court, which was the first court to open the court annexed mediation in an institutionalized scheme. The band of lawyers in the Madras High Court, they took a great pain, headed by Mr. Sriram Panchu, who was also a mediator for this Babri Masjid issue. All the band of lawyers, they took a great initiative and made our Madras High Court the first High Court to introduce court annexed mediation. We should be really proud of it. Then let us see what mediation is. Mediation is a process wherein a third party comes into the picture, works with the parties, and help them to derive at a solution. Here, there is no judgment or there is no analyzing the case and all. It is purely left to the parties. He cannot impose his decision, but he controls the entire process. The process itself is voluntary. Nobody can compel anyone to attend the mediation session. However, even that, they have got liberty to terminate the mediation at any point of time if they feel that the process of mediation is not going to help them in any manner. They have got the liberty to terminate that. So full freedom is given to them for the mediation. Next is that the confidentiality is another important issue. The mediator is taking all whatever they say. He is not supposed to reveal it to anyone. He should adhere to all the informations, analyze the possibility of any settlement, and he cannot dictate or ask them to do or undo things. But he can only suggest. He can only suggest the alternative, and if the alternative, if both of them are interested, they can come for and reach an amicable settlement by way of an agreement. So here, the chances of appeal is very minimal, and again, parties are bound by their own agreement, because it is a win-win situation for both, and nobody will go for challenging that, because already they have decided, and only based on their decision, the mediator will help them to resolve the issue. The actual work of the mediator is, first, he should give an introductory section of what is mediation to them. They should know what it is. They should not be taken aback. He should give an introductory session which comprises of explaining what the mediation process is. The process is asking them their entire case. After hearing their entire case, he should patiently listen to it, and after listening to it, he should also hear the other side. After hearing the other side, he should first focus on the problem, where exactly the problem lies, and he should suggest means and ways for them to come out of the solution and to end by writing an agreement. This process of mediation, I have taken a YouTube presentation. That YouTube presentation, actually, I wanted to do it here, but unfortunately, because of some technical issues, cannot be made here. But on the other hand, I have pasted it in the chart, and I request you to kindly go through after this session is over, so that you can have a idea about what is mediation. It is an actual live demonstration of a divorce case, a matrimonial issue concerning a divorce and illegal arrangement between a couples. So that chat, I request you to kindly go through it. The problem, the secrets and other things are given in the description. You can go through the description and then see the case. It is very a live demonstration. And if you see that, you will get some idea of what is mediation, right? Then certain important features of mediation I would like to explain. That is, the first is the third party intervention. The third party has got no say or no interest in the issue. Second, the prevailing system is adversarial jurisprudence, and here it is not that, it is consensual. Then the party can decide their case, and the mediator is not like a judge. He cannot judge it. He can only help them for them to come out their own solutions. Strict legal rules are not applicable here. It is so flexible. It is so flexible that the role of the lawyers are only like a consultant. They are also allowed. They are also allowed to sit among the in the mediation along with the parties. They can participate, and in fact, we want the lawyers to participate. That will solve so many issues, because they can understand the problem, explain the same to their clients, and help to resolve the issue. And most of the lawyers are operating like anything, and problems are getting solved in mediation. The only alternative for this types of backlog of cases, which is prevalent, is only the solution is mediation, right? Now I request, if you have got any question, you can please ask.
So thank you, Mr. Narayan, sir. It was more energetic to hear from you, sir, as always. Into the Q&A session, right? So let me see. There was a question from one person in B. Let me check that. Okay. Sanofer, are you putting Suraj on?
Yes, Karthik, he's on stage.
Suraj.
Good evening.
Suraj, you can ask the question to Narayanan, sir. That is a question to Narayanan. About the mediation.
Hello. So can you hear me, sir?
Hi.
Yes, we can. Yes, we can hear you.
Yes, sir. Sir, my question to you, sir. Is the mediation settlement agreement binding in nature, since we are yet to ratify the same, sir, in India?
Sir, the problem is already Mr. Indovijayan, the earlier speaker, clearly dealt with the whole issue. I'll put it to you like this. Here, there are two types of mediation: pre-litigative and post-litigative. With regarding to the post-litigative, the court annexed mediation that is being referred to the mediators. After the end of the mediation, if there is no agreement, or if the whole issue is not resolved, then it will be remitted back. If the issues, if they reach a settlement there, that settlement will be recorded. Both the parties to the mediation will sign the same, and it will be more or less as a recommendatory thing, and submit the same to the judges for them to act upon it. So, for the enforcement of the agreement, as a civil court decree, that can be executed. Right?
Yes, sir. Okay, sir. Thank you, sir.
Thank you so much, Suraj, for the question. And Narayan sir, I have just one more question before I put on a question to Mr. Inba sir. That question is, how an international dispute is subject to mediation?
Hello?
Yeah, can you hear me, sir?
Sir, I think this question can be well answered by Mr. Inba Vijayan, who is actually conducting the international mediation.
Yeah, okay, sir. Thank you so much, sir.
When he is there, I should not talk.
Thank you. Thank you, Mr. Narayan. Mr. Karthik, it is quite interesting how to initiate a mediation, particularly in an international perspective. It's all depending upon what category of mediation we are opting. Whether it is going to be agreement-based mediation, or whether it's going to be a private mediation, or whether it's going to be a court-annexed mediation. If it is going to be a private mediation or an agreement-based mediation, obviously the parties would have an agreement to mediate. That is like arrangement of a mediation clause. If they have a hybrid mediation or a dispute resolution clause, eventually there will be a concept called med-R clause. Mediate first, give a certain time. If it is successful, then that ends. If it is unsuccessful, then it can be taken to arbitration. If you have a med-R clause, then that international disputes can be taken to mediation.
Thank you so much, sir. And since we're exceeding time, I just have one last question to you, sir. And this is from Mr. Sakti, who is advisor for our Forum B, and he would like to ask the question.
Good evening, Mr. Inba Vijayan sir. I'm Shaktivel from Qatar. It was a really wonderful session, and you've given a lot of information about mediation, and it has got a lot of restrictions also, like to begin with. Sir, I have a question to you, because it seems it will grow like arbitration mediation also. It's a binding nature. In what way it will impact ADR in the developing countries, especially in India?
It is going to be a positive effect. It is not going to be what you can say like how the earlier regime was happening regarding the ADR mechanism. This particular restrictions or reservations, what has been suggested by the Singapore Convention, when we are going to adopt this law, the mediation law in our country, initially we have to adhere to the principle of that particular convention. And once we are going to opt, we are giving an options for the parties to accept. First, it's all acceptance of this ADR mechanism. This particular convention, even though it has a reservation, it is going to give an increase in the acceptance rate of litigants opting for ADR, particularly mediation. Anyway, arbitration has grown a lot. As Professor Kai was highlighting, it was that for the past 24 years, the laws that Karthikeyan also was mentioning about it, but still it is not reaching the other ADR mechanisms yet to reach. With this convention, even though with the reservation, it will have a good reach and it will be a good beginning.
Thank you, sir.
So thank you so much, sir. I thought of wrapping it up, but there is one important question I just want to get back to you. So what is the career pathway to an young professional to become a mediator? Maybe it should help those students who are part of this.
Okay, I think a reasonable number of students are participating. Reasonable number of students are participating in this particular webinar. As a career opportunity, it is always better you have to just get involved in mediation as parties representative. As it is a confidential process, anyway, the parties can be represented by lawyers or some representatives. You take that path. Initially, just take the path. Then you'll get an opportunity like you can be a future mediator, you can be an academician in mediation, and you can also be an advocate who is representing the parties in the mediation. 3 opportunities are there, but all depends upon your personal interest. The career path is very clear, and in the what way you are going to take and you are going to facilitate this mediation process, you are going to get that opportunity.
Thank you for a wonderful answer, sir. That should be really helpful to those young minds who are planning to get into mediation. And with this, we should be wrapping up for today. And before that, I will request everyone to go to the feedback, which has been posted in chat, and then provide your feedback. And let me welcome Mr. Vasant, Executive Committee Member B, to end this wonderful session with a word of thanks. Please, Vasant.
A very pleasant evening to you all. Distinguished speakers, respected dignitaries, invitees, participants from various walks of life, it gives me immense pleasure to propose the vote of thanks in this remarkable webinar on mediation. On behalf of BEAM, I take this opportunity to express our sincere gratitude to all our keynote speakers for graciously accepting our invitation and for sharing their wide knowledge and experience through this knowledge sharing platform. I extend my sincere thanks to the Principal, Government Law College, Viluppuram, Dr. Kayavali ma'am, for her insightful speech. Thank you so much, ma'am. I would also like to express our heartfelt thanks to Mr. Inba Vijayan, International Arbitrator and Managing Partner, Global LLP, for enlightening us on the topic Singapore Convention on Mediation. Thank you so much, sir.
Thank you, Mr. Vasant.
In this evening, we also witnessed an interactive session. We also witnessed an interactive session about mediation process by Mr. R. Narayanan, Advocate and Mediator, Madras High Court. We remain grateful to you, sir, for this informative session on mediation. Thank you, sir.
Thank you, sir. Thank you very much.
I would like to extend our sincere thanks to all the enthusiastic participants who spent their valuable time to attend this webinar. Thank you. We welcome you all to join us again in our next webinar to be held on 10th October 2020 on the topic Construction Arbitration. We will share the details soon. Thank you all for being with us. See you soon in our next webinar. Thank you. Thank you so much.